Shabana Mahmood's fierce battle against new sentencing guidelines, a fight for fairness or a power grab. This week, the UK political landscape is bracing for a showdown over controversial new sentencing guidelines that have sparked outrage and ignited a fierce debate about fairness, justice, and the delicate balance of power within the judicial system. At the heart of the storm is Labour MP Shabana Mahmood, who is poised to introduce a bill to the House of Commons aimed at overturning a contentious requirement for pre-sentence reports in specific cases. The new guidelines, issued by the Sentencing Council for England and Wales, mandate that judges and magistrates consult pre-sentence reports before sentencing individuals from ethnic or religious minorities, young adults, abuse survivors, and pregnant women. While proponents argue this ensures a more nuanced and compassionate approach, critics, led by Mahmood, see it as discriminatory and potentially leading to disparate sentencing. The seemingly innocuous addition of pre-sentence reports for these vulnerable groups has ignited a firestorm of controversy, raising fundamental questions about impartiality and the potential for unconscious bias to influence judicial decisions. The core argument is not about the value of pre-sentence reports in general. They are widely accepted as crucial tools for informed sentencing, but about the targeted application of this requirement based on protected characteristics. This targeted approach, critics contend, risks inadvertently reinforcing existing societal biases and perpetuating inequalities within the justice system. The Sentencing Council, in a letter to Mahmood, defended its guidelines, asserting that the pre-sentence report requirement simply ensures judges have complete information about the offender, including the impact of the crime on victims. They emphasize that the guidelines focus solely on information provision, rejecting accusations of bias or discriminatory intent. The letter concludes by stating that the rule of law demands fair and just treatment of all offenders, predicated on a full understanding of the circumstances. However, Mahmood's response was swift and uncompromising. She vehemently denounced the guidelines as unacceptable, highlighting concerns that they could lead to discriminatory outcomes and undermining the principles of equal justice. Her promise to legislate, should the Council refuse to retract the guidelines, underscores the gravity of the situation and her unwavering determination to challenge the established authority. The Prime Minister, Keir Starmer, also expressed his disappointment with the Council's response, signaling a significant rift within the government's ranks and leaving the future of the guidelines hanging precariously in the balance. His statement, ominously adding that all options are on the table, hints at the potential for far-reaching consequences, including significant government intervention. Beyond the immediate legislative battle, the conflict reveals a deeper power struggle between the government and the Sentencing Council. Justice Secretary Mahmood is reportedly exploring a more radical long-term solution, granting ministers the power to veto or amend the Council's instructions before they are implemented. This would represent a significant shift in the balance of power, potentially undermining the Council's independence and raising concerns about political interference in judicial matters. This move reflects a broader review Mahmood has commissioned into the Council's role and powers. Sources suggest she's actively seeking mechanisms to grant Parliament and the government greater control over the Council's recommendations. This pursuit of greater influence is indicative of a larger debate surrounding the appropriate level of government oversight in the judicial process and the potential for political motivations to influence sentencing guidelines. The controversy underscores the complex interplay between policy, politics, and the pursuit of justice. While the immediate focus is on the fate of the new guidelines, the underlying issues, the risk of biased sentencing, the independence of judicial bodies, and the appropriate balance of power between the government and these bodies, demand careful consideration. The coming weeks will be crucial in determining the outcome of this battle, with far-reaching implications for the future of the UK's justice system and the delicate balance between fairness, equity, and the rule of law. The debate extends beyond the specifics of pre-sentence reports. It's a clash of philosophies regarding the role of government in shaping judicial practice and ensuring equitable treatment under the law. The fight is far from over, and the eyes of the nation are fixed on Parliament as Shabana Mahmood prepares to take center stage in this pivotal moment for the UK's legal system. The outcome will not only impact sentencing practices, but will also shape the ongoing discourse on judicial independence and the government's role in maintaining fairness and equality within the justice system. This is more than just a debate about pre-sentence reports. It's a fundamental discussion about the very principles upon which the UK's justice system is built.